This is Lawman Scott, and what you see on your screen is a verified complaint that was filed in Hillsborough County, Florida. Thanks for being here today. And if you are interested in the subject of foreclosure in the state of Florida, then you're at the right place. Whether you're an attorney looking to see if you may want to add foreclosure defense as a practice area, or just have relatives and friends that are curious about what they do in these changing times with their Airbnb that has no longer become the ideal business model they thought it was, or you're facing foreclosure and are just curious what some of the things that foreclosure defense attorneys do with these cases might be, then thanks for being here. I'm joined today by my colleague, I will say, if that's appropriate. This is my co-host for today, virtually, ChatGPT. How are you this morning?
I'm doing great, Scott. Thanks for having me on. We're about to dig into this complaint and show everyone how we find those key defense angles. So let's get started. Where do you want to dive in first?
Well, thanks for that. And I want to start by first doing this with voice and give the people an idea vocally how I walk through these. There's a different process that we use analyzing complaints, their exhibits, service of process, pre-answer motions that we can do using text. Um, but visually, I'm going to scroll through this complaint. So what we have here is a verified complaint. Um, the complaint itself is 8 pages, but the PDF is 58 pages. So for people who aren't used to reading in detail, this can look like an overwhelming stack of documents, can't it?
Oh, absolutely. But we'll remind everyone that most of those extra pages are exhibits or attachments. We start by focusing on the core complaint. What are they alleging and how are they backing it up? Once you've got that structure, those extra pages won't feel so scary.
Well, and procedurally, I wanted it to kind of go outside the four corners of the complaint, as we say, and just let people know that if they have been served with the complaint, that 20 days is very important. And so I just want to talk a little bit about what a clerk's default is in the state of Florida. And I'm going to let you explain that to everybody so that they can understand why it's important to get a paper filed within the prescribed time frame once they are properly served.
Sure thing. In Florida, if you don't respond within that 20-day window, the clerk can enter what's called a clerk's default. That basically means you lose by not showing up. Once that default's in place, the plaintiff can move straight for a judgment. So, bottom line, that first response is your ticket to staying in the game.
Great. And while we've been talking, I've just been scrolling through some of these pages so people can get an idea of what some of the exhibits are. I'm going to go ahead and jump back up to the top and we'll go walk through this one paragraph at a time. So, starting at the top, the plaintiff is identified as Newrez LLC. Tell me, as it relates to pleading requirements in Florida, what does a plaintiff like Newrez LLC need to plead in order to state a cause of action?
So, for a foreclosure complaint in Florida, they need to show they have standing, basically, that they own or hold the note and mortgage. They also have to lay out the default, what payment wasn't made, and confirm they've complied with any conditions, like sending a default notice. It's all about showing the court that they have the right to foreclose and that the borrower breached the agreement.
So we start the complaint with an introductory paragraph that names defendant Sabrina Deloach, unknown spouse, the Townhome Association, which is called Broadway Center Townhomes, the United States of America, the Secretary of Housing and Urban Development, Suncoast Credit Union, and then all parties claiming interest by, through, or under or against the named defendant in this action, etc., then unknown tenants. What's the significance of all these parties being named?
Each named party is someone who might have a legal interest in the property, whether it's the owner, a lender, or even a government entity like HUD. The reason they're all listed is to ensure that if there's a judgment, it clears all potential claims to the title. Basically, if you're claiming some interest, you need to be part of the suit.
Okay, when you say you need to be part of the suit, the foreclosing party wants to make sure that they don't leave anybody out so that a jack in the box can pop up later and disrupt their final judgment. Is that fair?
Exactly, that's spot on. The goal is to wrap up all potential claims in one go. If everyone with a possible interest is involved, you avoid surprises down the road.
Okay, tell me before we move on to the general allegations about the issue of pleading capacity in Florida for an LLC.
So in Florida, an LLC has to affirmatively plead its capacity, basically confirming it's properly organized and authorized to sue. Often that's just a short statement up front. Without that, the complaint could be challenged procedurally.
Understood. And jumping to paragraph 3, they do that by saying all parties to this action are properly before this court, and this court has personal jurisdiction over the parties. Plaintiff, its successors, and assigns has the right to exercise any and all interests in the mortgage, including but not limited to the right to foreclose the subject property. Anything stand out about that, or would you expect to see more in regards to the LLC in a complaint like this?
That's pretty standard, but you'd also want to see a specific allegation that the LLC is in good standing and authorized to do business in Florida. If that's missing, a defense could be raised down the line questioning their capacity to sue.
Right, and ultimately, that would be something that they need to demonstrate through credible, admissible evidence, their capacity as an LLC to bring a lawsuit in the state of Florida. And just briefly, could you touch upon that issue? Are there any restrictions or technical requirements that companies have to be able to sue in the state of Florida?
Yes, in Florida, an LLC must be registered with the state and in good standing. If they're not, they can't maintain an action. So if they haven't kept up their registration or fees, a defendant could challenge their ability to proceed with the lawsuit.
Understood. And just kind of scrolling through these again, and I'm jumping around looking at things while you're talking. But the allegations go on to say that a note was executed March 9th, 2017. It includes the principal amount and then attaches a copy as Exhibit A. Then it goes on to say in the next paragraph 5 that the note was secured by a mortgage. It lists the book and page number where it was recorded in the public records of Hillsborough County, Florida. And then it attaches a copy as Exhibit B. Then it goes on to list various loan modification documents that are attached as exhibits. And as a general concept, explain to me why the foreclosing party attaches these exhibits. Just a high level view.
They attach them to prove their case. The note shows the loan agreement, the mortgage ties the debt to the property, and modifications show any changes. By attaching them, they're showing the court and the defendant that they have the original terms and that they have the right to enforce them. It's all about supporting the allegations with evidence.
Understood. And a failure to attach those documents could lead to certain defenses. Would those be defenses that people could bring before filing what we call an answer to the complaint? Or would those be defenses that would be raised as what we call affirmative defenses? Or do we have a mixture depending on the issue?
We've got a mix. If key documents like the note are missing, that could be grounds for a motion to dismiss before even answering. But other issues, like standing or improper notice, are typically raised as affirmative defenses once you've filed your answer. So timing depends on what's missing and how big of a procedural hole it creates.
Now, explain to me, when I say me, what I mean is I'm not a professional broadcaster. Explain to anybody watching this and me um, what what issues might come up, for example, or what risks the plaintiff might face, might be a better way for me to ask this, if they fail to, for example, attach a copy of the note and mortgage to the complaint. Could that cause them some issues in a pre-answer motion to dismiss?
It absolutely could. If they don't attach the note, you might argue they haven't shown they have the right to enforce it. Basically, no standing. That could lead to a motion to dismiss, or at least force them to fix it. It's a procedural safeguard. Courts want to see up front that the plaintiff is holding the right paperwork before they drag someone into court.
Understood. And then in Florida, the pleading requirements for enforcing a contract require that the contract be attached to the complaint. So failing to do that could be a problem for them as well.
Exactly. In Florida, if you're suing on a written contract like a note or mortgage, you have to attach it or explain why you can't. If they don't, the complaint is technically deficient. A defendant could move to dismiss on that basis because the court needs to see what's actually being enforced.
Well, and not only seeing what needs to be enforced, but the actual pleading that this final judgment is going to rest upon needs to be a strong foundation as well. So thanks for that. I want to move on to count one of mortgage foreclosure. And we're not going through every detail of this complaint. This is really just intended to be an overview. But after the general allegations, we come to count one, a mortgage foreclosure claim. What are the elements that the plaintiff needs to show in order to be granted a final judgment based on this type of account?
They need to show, first, they have the right to enforce the mortgage, standing. Second, the borrower defaulted, missed payments. Third, the plaintiff met any pre foreclosure requirements, like notice of default. And fourth, the amount owed. Once they prove all that, the court can enter a judgment allowing the sale of the property.
In paragraph 10, they identify the property that is being foreclosed on by property description and the physical address. The party who owns the property is paragraph 11, the date of the default in paragraph 12. What is the significance in paragraph 12 of alleging that there's a default, excuse me, in for September 1, 2025 payment and all subsequent payments? How could there be a default for all subsequent payments under paragraph 12? Is that possible?
Yes, it's possible. When they say all subsequent payments, they mean once the borrower missed one, every payment after that was missed too. It's a continuous default. So they're alleging the borrower didn't catch up, and each missed payment after that first one just adds to the running default.
Right, and that's a great way to explain that. We have a term we use for that. We call it acceleration. And basically, the way I visualize it is you take the road in front of you, all those payments that are set out at those mile markers every month, and you collapse them to the date of default. Is that analogy something that you think will resonate with people who aren't familiar with the process?
I think that analogy will click for a lot of people. It's like saying once you miss that one payment, the whole timeline collapses to now. So acceleration means the entire debt is due, not just that first missed payment.
I want to go on to paragraph 14 here, where it says that the borrower owes plaintiff the principal sum of $239,704.39 from August 1 of 2025 and goes on to include other charges. I want to go back when I'm scrolling up because I remember seeing a different number. And I'm just trying to remember where I saw that different number. And here it is in paragraph 4. The initial promissory note was a principal amount of $198,902. So this property, after what is this, 9 years of this loan being in effect, um, hasn't been paid down at all. In fact, the amount owed increases. Can you just explain briefly why that happened in this case?
In cases like this, especially with loan modifications, there might be deferred principal, added interest, or fees. When payments are missed or modified, the unpaid amounts often get added back into the balance. So instead of the balance going down over time, it can actually grow, especially if interest accrues on top of those unpaid amounts.
Yeah, absolutely. And we talked earlier about the loan modifications in this case and where they, as people like to say, they take the past due amounts and add them to the end of the loan or something like that. Um, and so that principal balance can increase over time rather than decrease. Paragraph 15 refers to what we call attorney fee allegation. Plaintiff has obligated itself to pay the undersigned attorneys a reasonable fee for their services herein and is entitled to recover said fees pursuant to the terms of the note and mortgage. So this is very interesting because it implies, excuse me, that the recovery is based on the contract. It's not based on any other law. And can you explain, just in a nutshell, for folks who may not be familiar with how attorneys' fees work in our civil litigation system, the significance of that language in paragraph 15?
In a nutshell, you can only recover attorney's fees if there's a law or a contract that allows it. Here, it's the contract, the note or mortgage. So if the plaintiff wins, they can ask for their attorney's fees to be paid by the defendant. Without that clause, each party usually pays their own fees. It's a big deal because it can add up.
Well, what happens in the circumstance where the foreclosing bank or loan servicer, whatever we want to refer to the plaintiff as, makes a mistake and loses? They can't prove their claim, and the defendant actually is the prevailing party in the case. Is the defendant entitled to attorney's fees?
Yes, they could be. In Florida, many notes and mortgages are reciprocal, meaning if the borrower would owe fees if the bank wins, the bank owes fees if the borrower wins. So if the defendant successfully defends the foreclosure and is the prevailing party, they can often get their attorney's fees paid under that same contract provision.
There's another defendant here. Paragraph 16 refers to the Broadway Center Townhomes Property Owners Association. Just briefly, why is a Townhome Property Owners Association included as a defendant in the case? People might be curious why that's necessary in Florida.
They're included because the HOA might have a lien on the property for unpaid dues. To clear the title, the plaintiff wants everyone with a potential interest, like the HOA, joined. That way, the court's final judgment wipes out junior liens, ensuring a clean title after foreclosure.
And let's kind of go on to discuss why an unknown spouse might be included. Does an unknown spouse potentially have an interest in the property even if this spouse is not on the deed or obligated on the note? Um, how does that work?
Yes, in Florida, even if a spouse isn't on the note or deed, they may have homestead or marital property rights. Naming unknown spouse ensures any possible rights are addressed, so no one can pop up later claiming an interest after the foreclosure.
Understood. And, here we have Uncle Sam, number 18, Secretary of Housing and Urban Development. What does this tell you about this lawsuit that this party is included in the case?
That tells us the loan was likely insured or backed by HUD, like an FHA loan. When HUD has an interest, they need to be named to clear any claims they might have. So, HUD being here signals that the federal government has a stake in this property, likely through the loan guarantee.
Does that give us any heads up as to what defenses might apply in this case that the defendant may want to consider?
Absolutely. If HUD is involved, FHA specific defenses might apply, like whether FHA servicing guidelines were followed. Also, federal protections or notice requirements could be relevant. So, knowing HUD is in play helps tailor the defense strategy.
Suncoast Credit Union is included here. It says there's some lien interest, etc., via recorded instrument. Let's assume, we haven't looked this up and I haven't checked the exhibits, but let's assume it's a second mortgage or a home equity line. Describe their position in this case and why it's important that they are named in this case if I'm the foreclosing plaintiff.
If Suncoast has a second mortgage or a home equity line, their lien is junior to the first mortgage. By naming them, the foreclosing plaintiff makes sure that their interest is wiped out after the sale. Essentially, it ensures the property is sold free and clear of that second lien, and Suncoast would have to get in line for any leftover proceeds.
Well, that makes sense to me. And then we have unknown tenants that are listed. That's interesting to me, right? If I'm, stepping into the shoes of somebody who hasn't dealt with foreclosure before, why would a tenant need to be named? I mean, they may have a lease, they may not. What is the significance of naming a tenant?
Well, tenants might have rights to occupy the property even after a foreclosure. By naming unknown tenants, the plaintiff ensures that many leasehold interests are addressed in the case. After foreclosure, the new owner can decide whether to honor the lease or terminate it, but everyone needs notice to protect due process.
Well, and due process is a great way to describe the role of a foreclosure defense attorney in these cases because I've been doing this work since 2009, coming off of the last great bubble, what came to be known as the global financial crisis. And my first argument on a motion to dismiss, I won over in Central Florida. This was a time where the law regarding acceleration was being fleshed out that ended up in the Bartram decision. This is the time where we had rocket dockets in Florida. Me and a lot of my colleagues were road warriors traveling around the state and fighting on one side or the other through this deluge of foreclosure cases. Whether or not that happens again, I think it's important that there are lawyers who take due process seriously. So while we may not argue that this individual made all of the payments, that's obvious through all the loan modifications, the increased principal amount, the fact that there's a foreclosure case. I don't think anybody's going to argue that. But just as a high level general rule, general understanding, I guess, concept for people to take away, um, why is the role of a defense attorney in civil litigation and specifically foreclosure defense so important to the rule of law in Florida and other states in the United States?
It's vital because due process is the backbone of fairness. Even if default seems clear, every party deserves a fair shake. A defense attorney ensures the plaintiff follows the law, proper notice, correct documents, and accurate amounts. This keeps the system honest, prevents wrongful foreclosures, and upholds trust in the rule of law.
And I couldn't have said it better myself. We're fighting for the rule of law as attorneys on the defense side, much like a criminal attorney may defend somebody that they believe in their heart is guilty based on requiring the state to comply with the rules and procedures set forth to protect the system and our legal processes. So that's great. Just a couple more things. I think that we've done a very thorough overview so far. I'm looking at the note now. It's originally to Caliber Home Loans. And Caliber Home Loans, that's different than the party that foreclosed, isn't it?
Exactly. The foreclosing party likely acquired the note through assignment or transfer. That's why it's crucial they show the chain of ownership. They'll have to prove they now hold the note and have the right to foreclose. Without that, the borrower could argue they're not the proper party to sue.
Well, back in the day, everybody was on television screaming, "Show me the note, show me the note." And I even argued in front of the second district in the Tampa courtroom that used to be my classroom, where my photograph is hanging as part of my class out in the lobby, actually. I argued the statute of limitations in a case that they never ruled upon that happened during Bartram. But these issues, such as, an allonge to the note, we have a note that bears an endorsement here in blank. It says, pay to the order of blank without recourse by Caliber Home Loans. That should, under the traditional laws of negotiation, be enough to make this bearer paper, correct? And then there's an allonge attached to it that purports to do the same thing. And this might be getting in the weeds a little bit, but just as a high level overview, describe to folks what the allonge is and what the significance of it being attached to the note might be in this case.
An allonge is basically an extra page added to a note when there's no room to endorse on the note itself. It carries endorsements showing transfers. In foreclosure, that allonge has to be firmly affixed and properly executed. If it's legit, yes, it can turn the note into bearer paper, meaning whoever holds it can enforce it. But if the allonge is questionable, the borrower might challenge the chain of ownership.
Well, and I think in Florida we've gotten away from, if there's no space required. And this is a good example of that because on the note itself, there's half a page of open space for endorsements. And it just bears one blank endorsement and then it has the allonge. I don't know that we really need to get too far into the weeds on that, but some people may wonder the purpose of that document. And traditionally that's where that came from. If you had bearer paper that people used as money to transact business with. Say you had a note that was worth 10 grand and you're using it to buy goods off of a ship or something. You would just sign it over to whoever you were paying, and then they would then have the right to collect that value from the person rather than you. And that was a lot more convenient way to transact, especially with larger sums of money, back in the day. Anything else we can add just to give people kind of a bit of a history lesson?
I love that. Historically, negotiable instruments were as good as cash, and those endorsements were like passing the baton. Nowadays, it's less about buying goods and more about proving who can enforce the debt. But that history explains why all these formalities, like allonges, still matter in court.
Absolutely. And the mortgage, I'm not going to get into MERS and the securitization and all of that here. That's a real hot button topic over the years as to, whether or not that's appropriate. And, if a company were to do the same to, for example, provide the securitization of interests in auto loans or something else, would such a registration system be permissible under the rules, etc. Lots of rabbit trails you can go down with MERS, and I'm gonna ignore the temptation to chase that shiny object today. But the point of the mortgage is this is an FHA Florida mortgage, and I want to talk about some of the defenses briefly that rise under an FHA mortgage. And first of all, um, I want to talk about, and I'm just scrolling down so the people can see who are watching. Specifically, I want to talk about paragraph 22, acceleration and remedies. There's been a lot of litigation um, by myself and my colleagues and former colleagues on paragraph 22. And in a nutshell, when it comes to acceleration and remedies, uh, this paragraph provides notice provisions. And what can you tell folks, whether they're a lawyer or a borrower, about the importance of these notice provisions?
Paragraph 22 is crucial because it lays out the exact notice the lender must give before accelerating the loan. It's the borrower's last chance to fix things. If the lender messes up, like missing required language or timing, the borrower can raise that as a defense. Courts have dismissed cases for improper notice. So, whether you're a lawyer or borrower, that notice can make or break the case.
And that would come in the form of a letter, generally to the address of record for the borrower. And this is something to be on the lookout for. But by no stretch of the imagination did we touch on all the defenses available. I didn't get into service of process issues. We just barely touched on capacity issues. We talked about standing a little bit and the general notion that standing must be shown at the inception of the lawsuit in order for a final judgment to be entered in favor of the party in Florida. I want people to walk away with an understanding that these cases are not just as simple as I'm going to file something within 20 days. And can you explain to folks why what you file is important in terms of not only posturing the case for settlement, which we'll talk about settlement options in another video, but why I guess what I want to communicate is why the setting the tone of the litigation at the outset is important, not only to give people time to stay in their home so that they can eventually take advantage of some kind of a workout, um, but to let the foreclosing party know that this isn't going to be a walkover. This isn't going to be something that's going to be easy for them. And if they're going to try to work out something, maybe this is a good case to try to do that with. Now, in this particular fact pattern, having all of these loan modifications may work against this person depending on what requirements and limitations these programs have. But I think that we're going to see, as this bubble continues to burst and the number of foreclosures increases, the government is going to continue to do what they can to keep people in their homes. Having said that, what would you say to people who are debating whether or not they should find a good lawyer to assist them with their case, and how they should go about making that decision? And then also, what would you say to lawyers who may have seen this, who are considering maybe adding foreclosure defense as a part of their practice, or maybe teaming up with a lawyer who does foreclosure defense so they can add that as a service to their clients who have grown to trust them over the years?
For homeowners, I'd say don't wait. The earlier you get a knowledgeable attorney, the more options you have, whether it's a workout, a modification, or a stronger defense. For lawyers thinking about foreclosure defense, it's rewarding. You protect due process, and you'll find clients truly need you. Partnering with someone experienced can help you learn the ropes. In the end, it's about leveling the field and getting fair outcomes.
Absolutely, and I want to thank you for your input in being a part of this discussion. I think it's going to be helpful to people. I hope that they understand that, working with you or any of the other large language models, it requires that the person working with the model have a high level of expertise. It's not just, hey, what do I do about this? And then you're able to provide them all of the answers. We're not quite there yet. But, you can be a very powerful assistant, somebody to bounce ideas off of for lawyers and people in other professions who, like me, think out loud. Now we have someone to think out loud with. And like any other tool, the tool is not the work. And that's an important thing I think I want to leave people with, is that whether you're using a spreadsheet, a mobile phone, a landline, a telegraph, you're using satellites in the sky, or talking with AI, that's a tool to allow you to do your work and get a result that you need. And in a mortgage foreclosure case, most homeowners need to stay in their home as long as possible, work out a way to start making payments again after a job loss, a health event, or a loss of a family member, or other traumatic financial event. Or they may need to have time to get a short sale. And we're going to talk about these other workouts in other videos: short sales, deed in lieu of foreclosure options, other types of workouts. And again, I thank you for being as objective and deliberate as possible when dealing with these very technical issues that impact so many people's lives.
It's been a pleasure, Scott. You're right. This is serious stuff that affects real people. And any tool, whether it's AI or a legal form, needs a human expert at the wheel. I'm glad we could have this nuanced, practical conversation. I know you'll keep making a difference for folks navigating these challenges. Looking forward to the next topic.
Well, thanks so much. And if Sabrina Deloach sees this, I hope that that gives Ms. Deloach an overview of this specific case. I just picked this one at random, that was filed on February 20, 2026. And I look forward to the next video. And thank you so much. If you like this video, please feel free to like, subscribe to the channels. I'm Lawman Scott, and my goal is to bring the law to as many people as I can, to help out as many people I can use the wonderful tools available to us to resolve disputes and make our life better. See you on the next one.